May it please the court, my name is James Stovall. With me will end, and I hope I get the name right. I do know her name. With me is Catalina Goodwin, also of the Knoxville Bar. We represent the appellant who was the petitioner below, Stephen Ross Johnson. I'd like to reserve 4 minutes for rebuttal.
4 minutes, very good.
This public records case has to do with one of the most important categories of employment records, especially for law enforcement employees. And that category is records of disciplinary investigations and actions. A review by an employer to determine whether an employee has violated employment standards of conduct, and if so, what should happen to that employee's employment. Should they be terminated? Should they be allowed to resign or some other, or be admonished? That's what the records at issue are about. In this case, for a forensic scientist who was employed by the Tennessee Bureau of Investigation, who was suspected of overtime abuse, of inaccurate timesheets, and also mislabeling files with times worked. An internal affairs or administrative investigation was conducted, and when the scientist was placed on leave, the leave letter specifically said this review is to see if you violated employment standards. The reviews conducted, the forensic scientist engaged an employment lawyer who began negotiations by phone and in writing with the general counsel's office for the TBI. And ultimately, the director at the time decided to terminate this forensic scientist for violations of a code of conduct applicable to all state employees, as well as a particular policy of the Department of Human Resources. A termination letter was not only drafted or prepared, but signed by the director with a CC to the State Department of HR. But as part of negotiations between the Employment Council and the General Counsel's office, this forensic scientist was allowed to resign. So records...
Can I jump you ahead just a little bit?
Yes.
Here? So in terms of the records that were obtained in the criminal case, those are under a limitation that they can only be shared among counsel, client, and and expert witnesses, right? That's the limitation, and that limitation remained in place through the criminal court's order. So your client could not, for example, take a document from that case and say, there's this expert for the state that's doing nefarious things, and I'm going to put it up on my blog, or I'm going to put it up on social media, or share it with a reporter.
That is right. The records at issue are prohibited from, public dissemination is prohibited of those records.
And we have no ultimate determination in this case from the Chancery Court as to whether these are public records or not, given the basis of dismissal being mootness and lack of willfulness. And
correct.
Okay. In terms of the proceedings below, there's I want to try to get a better grasp on this bifurcation that occurs. So we have a bifurcation by the chancellor in this case, and the chancellor says, step one, I'm going to figure out whether they're public records or not. That's essentially the determination I'm making. And then if they're public records, then we'll figure out whether it was willful or not. And that's the direction you have going into the hearing, right? That willfulness is not on the table, that's not being addressed. Whatever you're presenting to the court, you're being directed that willfulness is step two. That's the if-then on it. Is that a fair characterization?
That is.
All right, so ultimately the final order you get is that it's moot based upon the records having been available through the criminal proceeding, and that there was no willfulness here based upon the affidavits that were submitted. And that's essentially the line of demarcation that's drawn. So a fair characterization, understanding?
That is.
Okay. All right.
So despite the bifurcation, the trial court went ahead and reached willfulness. even though argument was shut down at the hearing that did occur on willfulness.
You never had an opportunity then, you're saying, to present anything you would have presented with regard to challenging willfulness based upon the trial court's handling of the procedure below?
Correct. And
So, reading your brief is sort of a somewhat, well, never, I was going to say novel, but just maybe never occurred to me. You're saying, in effect, is what the Public Record Act does is not just provide you documents, it also provides you determination that in fact, the documents you've requested are in fact public.
And that's right. That's one piece of the judicial review of the denial. Was
Okay.
it?
Yeah, so I'm curious then, what happens in a circumstance like this where you're under a protective order from a criminal court judge, you've got them from another source through the Public Records Act? Do you then just go, well, I can ignore the protective order in the criminal case because I received them through the Public Records Act and I get to post them on a blog, for instance?
Yes. If we had gotten them as public records, and Judge Sword, the criminal court judge, would have had no problem with that. He was treating them, and in fact, there was one exception to the protective order, which is why we have them here. The criminal court allowed us to file them under seal in the public records matter to aid the chancellor's determination. So the criminal court was clear. It wasn't for him to decide whether they were public records.
And there's an express indication of that from the criminal court judge, correct?
Correct.
Judge Sword says, that's for the chancellor.
That's for the
not me."
Chancery Court. And if the Chancery Court decides they're public, you can do whatever you want with them. But in this court, you cannot.
So you had a certification in a criminal case that the documents produced there were all the documents that were available. How does a respondent to a Public Record Act claim establish that fact? I mean, one of the complaints here is, well, no, that is not the full universe of documents. And I appreciate that you might have a situation like this where some of the documents reference letters that may not show up. That may be the easy case, but there's really no way to know for sure if that is every document in a record. So how is that supposed to work in practice?
Well, I think it could be different every time. But there's an important clarification on that statement of completeness that Your Honor is talking about. What the declarations say is that the complete investigative file was handed over to the criminal court. And so one of the reasons why we say this was still an open issue, whether the declarations also acknowledged that the scientist supervisor conducted post-resignation review of a handful of her cases. There were no records about that. It's not clear. Maybe there were no documents about that review, but that review was not part of the quote-unquote investigative file. And this is, I think, a big part of maybe where the parties have missed each other. The way that TBI approached this, they have an investigative file and there's a personnel file, and never the twain shall meet. And so if it wasn't so when they say that it's complete, they're not saying that all personnel information has been provided.
So I see. Okay, so you're saying that there, in fact, is probably likely more here.
I think so. Here's one reason why. She resigned in February of 2016. The investigation didn't close for another year and a half. So I find it hard to believe there wouldn't be some documentation.
You mentioned the Rule 11. Is that still a live
It is.
thing? So how does this all play in the Rule 11? If at all, does it matter? Do we care?
I don't think it matters to the Rule 11 because again, if depending on how that is decided, could it matter if there's remand? If there is a new trial, then it could have consequences for the criminal case. But I don't think the decision affects whether the records are public.
In the criminal case, is that still a direct appeal or is this post-conviction?
It's direct.
Okay.
So the issue, one of the issues, we've talked about mootness a little bit, but the real legal issue that's underlying the and the disagreement between these parties is a tension between the investigative records exception and two different provisions of the Public Records Act.
But the trial court didn't get there.
The trial court did not get there.
We have no ruling in terms of whether these are public records or not. So, and if this court was to wade into whether this is actually a public record or not, we're doing so without any ruling from below on whether these are public records.
You would be the first ones to do that. That is right. But that I think that it is fully, it's fully briefed. It's a discrete legal issue. It's a question of statutory interpretation. So we're giving the court alternatives today. I mean, I think that
although potentially we do have factual questions here in terms of, and the state says, well, it wasn't disciplinary in nature. Where was it? When was it put into which folder, and time periods on this? And there are some factual questions here that could become relevant in terms of whether something's a public record or not, right?
There are factual questions, and that's one reason we asked to be permitted to have live testimony at the hearing. And I think that our position is not that a trial court is required to have live witnesses every time, but it's certainly not prohibited by the Act. And what the Act refers to, a show cause hearing where the state has to show by a preponderance of the evidence, and the trial court's supposed to make factual findings. I see my time's expiring.
Thank you, Mr. Stovall. All right, we'll hear from the state.
Good morning. My name is Ryan Gallagher. I'm here on behalf of the TBI with my co-counsel, Kristen Bell and Rachel Appellant. May it please the court. This case involves a request for records and a request for attorney's fees. The request for records is moot because the petitioner already has the records.
General, I'm struggling with that in terms of mootness here. And you have, under the Public Records Act, one of the core aspects of this is that it is a public record, that I can share this document with anybody that I want in the entire world. And here, in the criminal proceedings, counsel's precluded from doing that. So how exactly is this moot? If counsel can't go and say, I've got this record that shows, let's say it shows that there's some kind of nefariousness was going on. I can't tell a reporter. I can't tell the public. How is that moot?
It's moot because the relief contemplated under the Public Records Act is access to the records.
Isn't it also the ability to share the document with broadly? Isn't that what I get by it being a public record?
That question, the underlying question about the publicity of the documents, courts decide that question for the purpose of determining whether to grant access to the records. Otherwise, you could just already have records and then seek a declaratory judgment about them. And that's not the purpose of the TPRA.
Is the position of the state of Tennessee that there's no difference between whether a document is limited in terms of whether it can be just viewed by counsel or expert witnesses or a client, or versus whether it can be shared with the public? I mean, I suspect that's not the position of the state of Tennessee across the board.
Correct, Your Honor. That's not the position. I mean, there's certainly a difference between not being able to disseminate the records and being able to disseminate the records. But what the petitioners are asking this court to do is to issue an opinion about the publicity of the records when they already have the records in their hand. And under Scripps, this court's decision in Scripps, the court was very clear that once the petitioner has the records in a public records case, the case is, in point of fact, moot, is the way they describe it.
Scripps doesn't have the facts here that we have a protective order in place with the documents in the petitioner's hands. I mean, so doesn't that make it distinguishable?
It's distinguishable, yes, certainly. Yes, Scripps did not have the protective order in place. but it's not distinguishable, and the factual basis of Scripps is the same as this case in terms of the petitioner having the records. And that was the court's analysis in Scripps. It's once the petitioner has the records, the case is moot. And that makes sense. I mean, under the Public Records Act 107-505A, it's petition for access to any such record. And then under 107-505E, it says, at the conclusion of the case, once the judgment is entered, the judgment shall order the respondent to disclose the records. So that's what the Public Records Act is doing here. It's about granting access to the records. It's not about declaratory judgments regarding the publicity of records. Those questions are only decided in terms of figuring out whether or not the petitioner has access to the records.
So the Public Records Act has nothing to do with sharing documents publicly. It's just about the person being able to access it.
According to the terms of the statute, yes. I mean, yes, it's about once they access the records, that's the case. I mean, there's the second issue is the attorney's fees issue. So there's that too. So once they have the records, the question about attorney's fees could potentially still be there. And this court's decision...
General, let me ask you about the process here. We have a bifurcation that occurs where the chancellor says, and correct me if I'm wrong, and maybe I've got this wrong, but step one, I'm going to figure out whether it's a public record or not. And step two, then I'm going to figure out willfulness. So I don't want to hear about willfulness in round one. I just want to hear about whether it's a public record. But then the ultimate ruling is, well, it's moot and it wasn't willful. And how can the chancellor get to the determination of willfulness when the proceedings have essentially been shut down as to willfulness at step one? We never got to step two here.
So 2 points, Your Honor. First, I would say the TBI's position on the willfulness finding is that the Chancery Court actually lacked subject matter jurisdiction to even make that finding in the first place. And the reason is that the petitioner obtained the records, but he did not obtain the records through the Public Records Act. He obtained the records through the criminal court order from Knox County. If you want to get attorney's fees under the Public Records Act, you have to get the records through the Public Records Act. You have to be the prevailing party in the Public Records Act. And this statute, 107-505, the attorney's fees provision, is a waiver of the state's sovereign immunity, so it should be strictly construed. And so if the petition for public records, if the petition for access to public records doesn't result in you getting the public records, you're not entitled to attorney's fees. So in this case, the petitioner would have got the records without ever filing a public records petition. So the prerequisite to awarding attorney's fees is not there. The prerequisite is obtaining the records. And this is rooted in the statutory language of 107-505G, where it says attorney's fees are appropriate for the costs in obtaining the records. If the records were not obtained under the public records...
Case law that suggests you can't just turn over the records as the state and then it precludes an attorney's fees award. Why isn't that case law applicable here? So for two reasons. I mean, first, that's from a factual standpoint, that's just not what has happened here. The TBI was court ordered to turn over the records. So it wasn't the kind of situation where a government entity denies the records request. Oh no, we've been sued. Now we're just going to give you the records to avoid litigating the lawsuit and just try to moot it. That's not what happened here. We denied the request and we were court ordered to give over the records. But I think that concern is avoided if you, in that case, Kersey, the court talks about the question is whether the petitioner would have got the records without filing the lawsuit. And that's a factual question, the way the court describes it in Kersey.
So in this case, the answer to that is that they would have got the records without filing the lawsuit. But in a case where the record should have been disclosed, but it was denied, then the lawsuit was filed, then the government just hands it over. In that kind of case, it was the lawsuit that triggered the disclosure of the records. And so in that case, the attorney's fee award would still be available. But in a case like this, where they would have got the records without the public records lawsuit, the attorney's fees is not appropriate.
The termination letter in this case, why isn't the correct me if I'm wrong here, but the initial response is we don't have any records, they're all with human resources. And with regard to disciplinary records, why isn't the termination letter a disciplinary record?
So the if I'm thinking of the right letter that you're referring to, that letter was, well, it's not disciplinary for one reason at least, is that she was never fired. She resigned.
She was permitted to resign.
She was permitted to resign, which technically isn't a disciplinary action. But yeah, that letter was turned over as part of the personnel file, the resignation letter.
But not the letter drafted to terminate her.
Correct, yes, because that letter was investigatory in nature.
Which was still in the possession of TBI, right? The termination letter was in TBI's possession, not Human Resources possession.
That is correct, yes, as part of the TBI's investigatory file.
The response is to the first inquiry with regard to disciplinary, there are no records, it's all with Department of Human Resources here. There's not a response that there's an investigative file here that includes stuff that you don't have a right to, and there's no statement to that effect, is there, by TBI?
Well, I think that the reason that TBI responded the way it did was based on the wording of the request. The first request asked for the personnel file.
Well, that's why I'm trying to figure out why a termination letter, drafted termination letter, is not a disciplinary record. And so if you have a request for disciplinary records, why isn't? That's what I'm still struggling with, and in terms of why that letter's not disciplinary in nature.
Well, one, again, because she wasn't disciplined. That part is explained in the declaration of Jeanne Broadwell. She explains how it's not a disciplinary record, and also it contains the factual results of the internal investigation into Special Agent Armory Cannon. It's factual. It's not just we're placing you on administrative leave, or here's my resignation letter. It involves the facts, the underlying facts, which were discovered through the investigation. And so that's why we believe that it's an investigatory record.
Was the administrative leave related documents still in TBI's possession?
The administrative leave document was part of her personnel file that was disclosed.
Okay, so that was with Department of Human Resources.
Yes, the letter that says we're going to put you on administrative leave pending an investigation. And then the termination letter that includes the factual results from the investigation, that was part of the investigatory file.
But is there any continuing assertion of an investigatory privilege with respect to these documents, or is that over and done with now?
Oh, no, we still believe that these records are closed under the investigatory records exception.
Right, it's not a privilege exception.
It's 107-504A2A, and it says, all investigative records of the Tennessee Bureau of Investigation are confidential. And so it doesn't just say the criminal investigations, it also includes internal investigations into TBI employees.
Can you pull documents into that file, like the timesheets here? And is that something, I mean, that's not prepared in the course of the investigation, and that's a document that was in existence, and can that be shielded under that exception?
We think so because the timesheets were not kept as an ordinary business record by the TBI. And this is explained in the declaration of Nancy Myers. Agent Cannon was on a working on under a special federal grant. So she was required to keep hard copy timesheets. And those timesheets were forwarded to the Department of Human Resources to be entered into Edison, the state's human resources software system. So these records weren't kept as ordinary business records by the TBI. The only reason that the TBI had the timesheets...
They weren't produced, though, as part of the investigation. I mean, they weren't... and she didn't create her timesheets in response to the investigation.
Yes, but they were only a part of the investigation. They were brought into the investigation. They weren't... In Scripps, the records were records that were ordinarily held by the agencies. But these were not. These timesheets were not ordinarily held by TBI. They were held by Department of Human Resources. TBI only had them as part of evidence in the investigation. And so I think it's distinguishable from Scripps on that basis.
Ultimately here, whether you're right or whether opposing counsel's right, that we have no ruling from the trial court in terms of whether these are public records or not, right? I mean, we have a mootness-based determination, and then there's no willfulness, and their attorney's fees are out. So we don't have a ruling on this question that we're reviewing, right? Yes,
that is correct. Yes, the Chancery Court did not rule on the underlying issue because it dismissed the case as moot. And I will briefly, in the time that I have left, address the public interest exception to mootness, which a petitioner is claiming applies here. All of the constitutional concerns that petitioner says justify an advisory opinion here do not apply. They apply to his client's criminal case.
Counsel, how is it advisory? If the court issues a ruling that says it wasn't moot, you go back, and if there's a determination made that it's a public record, then that affects whether or not the record can be shared or not. I mean, that renders a real-world consequence of the decision of the court. So how exactly is it an advisory opinion?
It's an advisory opinion because courts only answer that question regarding publicity for the sake of determining whether the petitioner obtains access. I see that I'm out of time, so I would conclude by asking the court to affirm the decision of the Chancery Court. Thank you.
Thank you. Mr. Stovall, we'll hear from you on rebuttal. I believe you have 4 minutes.
We just heard this, what I've called earlier, the confusion or the way that TBI has approached this, as if the requests concern files and not records or information. So what the request actually sought was not the scientist's personnel file. Personnel records can be in more than one place. What was requested was all personnel records, including performance appraisals, all disciplinary process records. I don't want to get into now whether it's only disciplinary if it ends up with a reprimand. I don't think that makes any sense. And the policies use the word discipline. She would have been terminated, but for a negotiated resolution. That is, I think we can agree with the state, at least the disciplinary process. That's what was asked for, all disciplinary process records. And in response, the agency did not indicate it had any responsive records. It said, after an agent leaves, you got to get personnel records from HR. And fortunately here, one piece of this correspondence was in the HR file. But if that hadn't made it to the HR file, we could have gotten the file from HR and not known any other personnel records or information existed. That response was misleading. That response violated the Public Records Act in and of itself. And I think that's an example of the judicial review that the statute requires.
So, Mr. Stovall, is there a separate Public Records Act case currently pending against the Department of Human Resources here?
There's
Okay.
not. The administrative leave notice, I forget which judge asked about it, that is a document that happened to be in both. So that was still in TBI's files as well, that notified her, but same thing, the response didn't indicate that the agency had any records and assert
So
that
the
exception.
TBI did have the administrative leave document still
It
in their
did.
possession when
It
they
did.
said they had no records and said that it was all with Department of Human Resources.
Correct. So that one, which I think they would, because the fact that that piece of paper at least made it to HR, and it was still in the TBI records as well. But the primary argument I think the state's making now, as it made below, is that there's no difference, at least in the public records context, between access and ability to use, and that's just not what the statute's about. I mean, publicity's not only about going to the press. We're not allowed to share it with anyone at all. So the public, that's not what access means under the Public Records Act. There's no restrictions under the statute. I mean,
So you couldn't share this with other defense attorneys who had had the same expert witness testify in cases involving their clients?
exactly. So there is a live dispute here. There's more than one live dispute because it's not clear that all personnel information, I mean, we have got to somehow cut through TBI's file construal of this. That's how, keep that in mind as you review their responses. So we produced the file. It is not clear that the personnel information that has been produced is complete. So there are at least two live disputes, whether the records are public, whether it's complete. Thank you.
All right, thank you, Mr. Stovall. The case is submitted. I thank counsel for both sides for the arguments. Very interesting. Thank you. We will be in recess till 1 p.m. Will you please recess court, please?